As of December 1st, 2019, the DWI laws of New Jersey were changed substantially. In that, now you don't have the automatic loss of your driving privileges as long as you do certain things. The most important thing is you still should have an attorney to go over everything, because there are many times that these cases can be defended. Remember, the state of New Jersey has the burden of proof in a DWI. They have to prove beyond a reasonable doubt that you operated the vehicle while you were under the influence of either alcohol or a drug. There is a standard regarding blood alcohol reading of 0.08. What that means in effect is the following. If you have a blood alcohol reading of over 0.08, then their presumption is that you were driving the car while you were intoxicated. Our job is to see if we can defend the action regarding various elements that the state has to meet in proving a case beyond a reasonable doubt. One is that you operated the car, B, that you operated the car in a manner that would demonstrate that you were intoxicated at the time that you did operate the vehicle. We defend these cases vigorously. We work with expert witnesses who make sure that everything that the police have to do in order to convict you is done properly. There are many times where we've been able to make motions, because there are various motions that one can make in defending these actions, where we have been able to get a good resolution for our client, and we've been able to get the client acquitted of the DWI. Now, I can give you a quick summary regarding the new law. The new law is, in effect, if you get between an 08 and 10, that's one level of violation. Between a 10 and 15 is a second level, and over 15 is the third level. Let me explain. Under the new law, with an 08 to 10, you lose your license, but if you get an interlock device, you only have to have the interlock device for 30 days. And if you get the interlock device, you do not lose your right to drive legally in New Jersey. You have to get an interlock license, which is a procedural thing that we would explain to you. But the key here is to get the interlock simultaneously to the day that you're in court. The second element is the 10 to 15. There, the interlock device is for 7 months. So again, if you got the interlock device, we could, and you get it simultaneously with when the case is disposed of in municipal court, you really don't lose your driving privilege. You have to get a special license, and you have to have the interlock device in for at least 7 months. Anything over a 0.15, though, you lose your license. You lose the ability to drive for at least 4 to 6 months. Now, those are the primary concerns. Now, there are various things that with the DWI, you have to go, you get mandatory fines, you get a mandatory insurance surcharge. These are very expensive. That's why these cases should be defended vigorously. And although they have liberalized the DWI laws regarding ultimately taking your ability to drive a vehicle, you should at all times get an attorney who's experienced in these matters like we are. And we can take care of this for you and guide you through the entire situation to your satisfaction.